How long are J1 waivers currently taking? What will happen in 2023 with J1 waivers with regards to how long it's going to take? These are critical issues that we're going to be discussing and more on this video, so stay tuned. Hi, my name is Kaushik Ranchad. I'm an immigration attorney representing clients across the United States and worldwide. We're going to be talking about the J1 waiver, what we expect in 2023, and let's get started. Well, first of all, let's talk about the different types of J1 waivers. There's the J1 no objection waiver. This could be a good option if you don't have US government funding, or if you're not a physician who is participating in ECFMG residency programs. The other options are the interested government agency waivers. One of the most popular ones for physicians are Conrad 30 waivers, but you have to work in an underserved area for 3 years, and you may not want to work in that underserved area, which is why the third option, the exceptional hardship waiver, which is what we're going to be focusing on in this video, is a popular option. Another option is a persecution waiver. However, it's limited in scope. We're not going to be discussing that option in this video, but check out my other videos on that. Another option that's not really looked at is sometimes it's just better to go back for 2 years. Maybe you don't have that much time in your J1 program, or you've already been back in your home country for a long amount of time. What we do find, however, is that a lot of times people can't go back even for a short amount of time because there's a war going on, because the situation is so bad that you can't go back. But this might be a good option for you, and it is an option to consider. Okay, before we dive into the processing times, I want to talk about the process for the I-612 J1 exceptional hardship waiver, because we've got to deconstruct the process so we can actually talk about the processing times. So the first step, I would say it's the first and the second, we do in conjunction. Filing the DS3035, that gets the third-party barcode page for you. That allows you to submit the actual J1 exceptional hardship waiver application with that third-party barcode page. The I-612, of course, needs to be completed and submitted to USCIS, but it's not just that. People think that this is an easy process. J1 waivers is probably one of the most complicated areas of law. So what we do is we prepare detailed legal brief in these cases, and also make sure we provide extensive documentation and a statement explaining the exceptional hardship. All of that's submitted to USCIS. So it will be submitted to USCIS. USCIS will review the case. When they're reviewing the case, they will determine whether or not there's exceptional hardship. You first of all have to have a qualifying relative. The qualifying relative is a US citizen spouse or child, or a lawful permanent resident spouse or child. If you do not have these qualifying relatives, then this is not even an option for you. So then you want to consider one of the other options that I mentioned in the very beginning of this video to determine whether or not you qualify for the exceptional hardship waiver. USCIS, when determining whether or not you qualify for an exceptional hardship waiver, they will look at, well, what are the hardships to your qualifying relative? What are the country conditions that your US citizen spouse or child or lawful permanent resident spouse or child would face if they went to your home country? Is there terrorism that's going on? Is there a high degree of pollution? Is there career hardship? Is there financial hardship? Would you not be able to make the same amount of money if you went to your home country? Is there health hardship? Is there mental health hardship? So we like to delve into all of these issues in detail, demonstrating the exceptional hardship. USCIS, they review your application. Then if they find that there is exceptional hardship, they will issue an I-613. What that basically means is that they're finding a Prima Facie finding of exceptional hardship. Well, what does that mean? That means that they're basically stating they're going to approve your case if the Department of State gives a favorable recommendation. If USC finds a Prima Facie finding of hardship, this means that USCIS agrees that we've made a showing of exceptional hardship. Now you might be asking, all right, that's great, but how do I know? Like, How do I stay informed? And of course, this process is a long one, so you want to know what's going on throughout the process. Well, you will be able to tell if this has happened in two ways. Not one, but yes, my friends, two. You'll know when USCIS sends the I-6013 to the Department of State, because on the USCIS website, it will say something to the effect of, on your date, your case was transferred to another agency for a non-advisory opinion. A few weeks later, then you can check the Department of State website, and it'll say the I-613 was received on XYZ date, and it will give the date. So you can see here that this is a two-step process. You not only have to get this approved on the USCIS end, but you got to get this approved with the Department of State as well. So Department of State then will review your case. Now, what Department of State is doing is they're evaluating the policy considerations, evaluating your hardships against the policies behind the J1 waiver program. Because remember that in the Department of State eyes and USCIS eyes, you came on the J1 program, you're going to learn about medicine, you're going to learn about whatever you're doing on your J1 program, and then you're going to take that back to your home country. So Department of State and USCIS says, why should we grant this waiver to you when you made the attestation that you were going to go back and take these skills back? Hence, there's this need to file the exceptional hardship waiver application. So on the Department of State end, they're looking at what were the policy considerations behind your program? How heavy should they weigh those policy considerations? For instance, in Fulbright programs, there's a strong burden of proof. With Fulbright scholars, they set a very high standard for these policy considerations, and that's why it's so hard to get approved, because Department of State weighs, in that situation, the Fulbright sponsors' views very heavily. While Department of State is reviewing your case, they can request sponsor views. This will happen if you've received government funding, both from the US side and from your home country. Now, on the US side, if you have US government funding, it is more difficult to get approved than if you receive, in most cases, of course, it's on a case-by-case basis, than if you receive government funding from your home country. What we typically see in our experience is that if USCIS has made that I-613 Prima Facie finding, in most of our cases, then Department of State will issue a favorable recommendation, but there has been some situations where they don't. It's been limited, but they do still look at the home government sponsor views. Now let's look at the processing times. Right now, it's taking anywhere from approximately, there's a range about 1.7 months to about 1 year and 10 months if there's no US government funding involved. If there's US government funding involved, there's the additional time that's involved in getting the sponsor views, and that can take about 6 months additional, depending upon who the sponsor is. One thing that's really important to note here is that we do expedite requests when they're warranted. On the USCIS end, we have been able to get these approved, but on the Department of State side recently, Department of State will not consider a request to expedite in most situations. Most of them get denied. We're very reluctant to take the request for expedite on because Department of State just routinely denies it. They're not being reasonable. The reason is because they're so backlogged, in my humble opinion. It's taking the Department of State 36 to 52 weeks right now. And that's where the backlog is with the Department of State. They're the ones that are taking the most amount of time to approve these cases. You might be wondering, well, what is the good news, Koshik? The good news is if we compare this year to last year, we are seeing times come down. Not a lot, I would say maybe about 2 months, maybe 3, but it is coming down. So in 2023, what I expect is this incremental improvement, and 2 months could make or break the difference of whether or not you're going to be in the US or not. So I am happy about this. USCIS is hiring staff, so I'm hoping that it might even be more than 2 months. But if I was going to just look at last year as a trend and use that information to extrapolate what's going to happen in the next year, it looks like about a 2-month decrease. Of course, I am a lawyer, not a fortune teller. I'm just going back off of the processing time data. That's what I hope to see. So I always am hoping for the best, but being prepared for the worst. And when you connect with our office, we like to lay out a plan for you in all different kinds of scenarios so you're prepared and know what the best path is for you. I want to thank you for taking the time to watch this video. I appreciate you. You're doing great things in this country as a physician, academic researcher, whatever you're doing in your J1 program. You are truly making a difference. I feel so honored and blessed to be working with many of J1 holders. And by watching this video, you're bettering yourself. By bettering yourself, you're bettering our country. And by bettering our country, you're bettering the world. Thank you. Bye for now.